The record date is June 14th, 2007. The CPI report, Child Protection in Iowa, brought to you by Vocal, Victims of Child Abuse Laws. You can watch our program on Mediacom Channel 15, Sunday afternoon at 1 o'clock. It's repeated again on Wednesday evening at 9:30. You can email us at vocaliowa@mchsi.com. My telephone number here in Des Moines is 515-276-3956, and John's number is 515-282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. CPI stands for Child Protection in Iowa, and that is the basic issues on which we spend our time and effort. One of them is to influence public policy as it relates to child abuse issues, and secondly, to help on a one-on-one basis with parents who are having difficulties with the Department of Human Services and with the juvenile court. And we found just very recently that one of the employees of the juvenile court has been found out. These are not issues that seem to be of great interest, apparently, to the media, because the report comes from the Waterloo Courier, but I notice that there's no such report from the Des Moines Register. We may have to contact the Des Moines Register and see if they're interested in such things as public employees who lie in court. Well, it doesn't seem to bother the Department of Human Services and the legal department of the Attorney General's office, legal counsels in the Attorney General's office, to go into court to win battles. Well, if their direction is to win, not to protect children, they know ways that is possible. And we're going to call on Don here to tell us the story from Buchanan County about a social worker who has decided to employ this method of winning cases. Don?
Okay, this report is dated June 12th, 2007. Social worker charged with perjury. A Buchanan County social worker was charged last week with 3 counts of perjury for allegedly filing false child welfare reports to the court. Marie Mahler, 39, of Cedar Falls, filed 3 reports between August 27, 2004 and October 7, 2004, used in a juvenile court case that she knew or reasonably should have known were false, and that the reports would be used by a judge to make a decision in the case, according to court records obtained by the Courier. Mailer entered a written plea of not guilty Thursday. According to court records, the case was to be determined whether or not a mother's parental rights should be terminated. That's the main issue. They're going after a mother's parental rights. And so the social worker has made up 3 abuse reports. And so the charge is that they are not true. Mailer repeatedly included misrepresentation of conversations, events, and relationships of the people involved with the case, according to court records. Court records say she claimed that Jessup police officers were called to the mother's home for a drug investigation in August 2004. Records indicate an officer was called to the home not for drugs, but to prevent an altercation between 2 siblings. No sign of drugs were found. That's interesting, and yet the social worker sticks it into a report that there were drugs. Roger Munns, spokesman for the Iowa Department of Human Services, confirmed Mailer is an employee of the department. Mailer received her social work license in 1998. She has no record of disciplinary action and is still on active duty, according to the department records. I'm guessing that whether or not there's records out there, that the DHS covers them up when the request is made to make the worker look good. Maybe they're there, maybe they're not. I wonder how many parents know of any rights out there that they have a right to complain when a social worker they believe has done wrong in their case. If they don't know, a parent can't complain. So therefore, there may not be a disciplinary action. Parents can complain all they want to their friends, but if they don't know how to complain to the DHS, it's a dead issue, except for the fact that they end up getting their rights terminated. This worker has been a social worker in Buchanan County since 1998. That's 7 years. In a parental rights termination case, it's 9 years. She's been on the job. In a parental rights termination case, the decision is made by a judge, Munn said. Yes, but I'll inject this, that a lot of the evidence comes out of the social worker's mouth and what she has written up to influence the judge. Very little of it comes from the side of the parents to protect themselves.
That's a pretty poor argument on the part of Munns to say, well, we didn't do anything wrong.
Correct.
The court did.
Correct.
Based on what DHS did wrong.
Correct. What's the judge supposed to do? He's supposed to weigh the evidence. And if the parent gets a lousy court-appointed attorney that won't put any evidence in for the parent, and the judge hears a lot of lies from the DHS, he weighs it all in the evidence, and the parent loses. So you can't necessarily criticize the judge in some cases. It goes on to say, people involved in the case, like biological parents, adoptive parents, or social workers, can give input to help the judge's decision. Well, how many parents, how many grandparents know about that? It's rare to have people charged with such a crime in these cases. Well, you don't see the county attorney charging the crimes, and he's the only one that has any knowledge on it. The parents come in there totally ignorant of the law. So what do you expect, Mr. Munns? He says, this is really quite unusual. Well, DHS has a way of making sure that it is quite unusual. The Delaware County Attorney has been appointed special prosecutor to the case because of a conflict of interest. The Buchanan County Attorney's Office has represented Mailer in juvenile court proceedings. See, whenever a parent goes to court in a China action, automatically a county attorney or assistant county attorney is assigned to it. But if there's a problem, a conflict of interest, the attorney for the parent needs to speak up and say, conflict of interest, remove that attorney. And then they're forced to go out and hire an attorney that's not connected with the DHS, not connected with the state of Iowa. So hopefully it eliminates the conflict of interest. In other words, an attorney that would lean toward the DHS, which they always do if they're court appointed, where does the money come from? It comes from the state of Iowa. The state of Iowa is the DHS, and it's all connected together. The county attorney said he couldn't comment on specifics about the case, but said perjury charges are often hard to investigate, especially when he doesn't want to, when his paycheck comes from the state. Yeah, that makes it pretty hard. I wouldn't want to be in his shoes. Well, and of course, if he investigated, it might implicate him in the crime. While the offenses occurred in 2004, the county attorney said Mailer is exempt from Iowa's statute of limitation law because she is still a state employee. In most felony cases, charges have to be filed within 3 years of the offense. However, that 3-year period begins for state employees only after they are no longer working for the state. Perjury is a Class D felony punishable by up to 5 years in prison. Okay, John?
Okay, we're going to be talking or listening to a fellow by the name of Michael Ferris. Michael Ferris is head of the Homeschool Legal Defense Association. We call it simply HSLDA. He's also chancellor of Patrick Henry College. He has a good deal of interest in the family because the Homeschool Legal Defense Association steps out to protect families, and one of the problems that they have is the Department of Human Services. Michael Ferris was instrumental in getting homeschool family law passed in Iowa, and did a magnificent job of assisting in that case. And he also comes up and picks up the pieces where the bureaucrats want to come in and snatch children from home schools. He has seen the worst of the cases with respect to denial of fundamental rights to parenthood. And so he's formed another organization now called parentalrights.org.
Would you repeat
That's
that again?
parentalrights.org is his new organization, and it is his intention to perpetuate or to bring about a change in the Constitution which will give proper recognition to the rights of parents to parent their child. We do not have that apparently in full force and effect. One would think that with the various court cases dating back as early as 1923, where the United States Supreme Court held that liberty protected by the Due Process Clause includes the right of parents to establish home and bring up children and to control the education of their own. And whereas in 1925 the United States Supreme Court has declared that the child is not a mere creature of the state, those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations. And another case in 1944. So there's been, in 1972, there's been case after case after case. In 1999, 2004, all kinds of background cases here where the court has stepped in and said without hesitation that parents have these rights. However, when push comes to shove, the bureaucrats will say you cannot claim a constitutional right unless it is found in the text of the Constitution. We can't just dream up rights. I don't know how they dreamed up the right of abortion and homosexual rights, but when it comes to parental rights, they say you're going to have to meet a tougher schedule, a tougher standard than are met in these other areas. Well, Michael Ferris says it's time that we place it in the Constitution. Now, that is a long-term battle, and he's going to explain that in his speech before homeschoolers here in Iowa when they met in convention in June of 2007. He was the keynote speaker at that convention. Here now, Michael Ferris.
Privileged to be here. It was an endurance contest yesterday, and I thought it was about mechanical failures. I found out about 15 minutes ago what the real reason was for my delay. I'll get to that in a second. But had flights canceled. Twice I was on the runway in different planes, and one time the computer broke, and the other time the fuel lines broke. And I landed in O'Hare at midnight last night and was able to get here about 9:30. So when conference speakers say they're glad to be here, I am really glad to be here. But I found out the real reason. I think that the reasons you were just told about God's providence are absolutely true. But an additional factor is my longtime friend Joanna Hicks was praying that I would speak later in the day because she couldn't get here this morning to hear me. And so where are you? There? Okay, there she is. Joanna and I have known each other since, sometime between when the Constitution was ratified and the Bill of Rights was promulgated, right in there. And so she is the grandmother of the homeschooling movement in Iowa, to be sure. And we love her and appreciate her. Glad that she could be here this afternoon. Well, I want to talk to you about two different paths that our country may go down. Path very dangerous proportions, and a path that would be one that we would all be happy to take our families down. As you know, most of you at least, my wife and I have 10 children. The irony is that I won a college speech contest when we were dating. My subject was the advocacy of zero population growth. That contest was on the same week as the original Earth Day, and I got paid $35 for advocating zero population growth in that contest. And for years, I celebrated Earth Day by buying $35 worth of disposable diapers. It's a celebration. This last weekend, our fourth daughter, Jessica, gave birth to our 9th grandchild, and we were really grateful for her in special ways because she didn't make homes. She had an APGAR score of 1. And yet on Monday, she was born on Thursday, and on Monday she was released from the hospital and she's fine. She wasn't breathing for a while, and they gave her oxygen artificially, they cleaned the mucus out of her lungs and got her going. And so we were really happy and especially grateful for our 9th grandchild. But this really, in many respects, is about that generation. It's what's going to happen. I was told a story just this week by a friend of mine that I've known for 30 years who had recently read a history book about a man, a nobleman in England. I'm guessing, I'm trying to remember exactly the dates, but it was approximately the early 1600s when this happened. Could have been a little later, but it's approximately correct. And he was convinced that England was short of the right kind of trees to build naval vessels. You need big, strong trees, big, huge trunks and branches and so on to have the right kind of timber to build naval vessels. And so he committed himself to going around the country planting acorns. And he planted acorns in all the he convinced the king to go along with this. He planted acorns in all the royal places that he could get away with, and then he convinced a lot of the noblemen to plant acorns in these places. And it was 100 plus years later when those trees were harvested to make the ship parts that defended England against Napoleon. If it wasn't for a person who was concerned and wanted to plant acorns generations before they were needed, then England wouldn't have been able to defend itself. And one of the challenges that a person in my position has is trying to convince people to take action today when the problems that I'm going to describe for you are down the road. Now, they're not 100 years away. They may be 5, they may be 7, they may be 10. I can't tell you exactly how long it will be until the problems that I'm going to describe for you arise. But I want you just to simply say, what will happen to us if we don't act today? Because today is the day that we need to be concerned about. In the early 1980s, a girl named Sheila Marie Seeley was 13 years old at the time, and she was engaged in improper behavior. She was engaged in improper behavior with her boyfriend, and I'll just leave it at that. I'm not, because of the young years here, but serious improper behavior in that regard. And she was smoking marijuana, and her parents found out about this serious improper behavior in these two spheres, and they grounded her. Seems appropriate to me. The girl went to her school counselors, who called them social workers, who decided that Sheila Marie needed to be removed from her home because the child's wishes on this matter were being adequately considered by the parents. So Sheila Marie was removed from her family and placed in foster care. And the foster care order was challenged in court and went all the way to the Supreme Court of Washington. The Supreme Court of Washington ruled that even though the parents' rules were reasonable and their method of enforcement was reasonable, the government's decision to remove this girl from her home and place her in foster care over the conflict of rules was not a violation of the parents' constitutional rights. The parents came to me on the 90th day after that state Supreme Court decision. Now, the Supreme Court of the United States will refuse such cases potentially, but you have to file paperwork within 90 days. And they came to see me at 4 o'clock in the afternoon in Olympia, Washington, when it was already 7 o'clock in Washington, D.C. And I'm pretty fast at what I do, but nobody's that fast. I would have had to have at least a week to get that done. It was impossible to take the case to the Supreme Court of the United States, given that they arrived when they did. A few weeks later, I got a case where I thought I could challenge all of this. Because if another 13-year-old, this time a boy, in Island County, Washington, had gone to his public school counselors, complaining about how often his kid was sent to church. And it turned out that the parents took him to church Sunday morning, Sunday night, and Wednesday. And that's just a brutal schedule at church. And so the social workers got the case from the school counselors. Social workers removed the child from home. I litigated the case in the Superior Court of Island County, Washington. And the judge ruled from the bench that once a week was enough church for any 13-year-old. And if the parents wanted this boy back, they had to agree to only take him to church once a week. Now, if this was the kid of the judge, fine. Let him decide how often he wanted his child to go to church. But the only basis of ordering a parent to not take a kid to church is if the church is somehow abusing the child, or the parents are abusing the child in a way that forfeits their right to make decisions, like if they were engaged in improper sexual behavior or something, some wacko cult thing, then okay. But that wouldn't mean you can go once a week. You just can't go at all. If there's that kind of extremist sort of thing going on, which I can't even think of any case that I've ever heard of an actual fact that's ever present such facts. It's hypothetically speaking only that we'd be talking about that. It is a parental call, not a governmental call, that the judge made. And the government aspires to be parents because the government aspires to run the world if you have the wrong philosophy of government. There are two basic philosophies of government that are competing in our nation today. One is the purpose of government is to protect life, liberty, and property, and to punish those who do evil. The other theory of government is the government is here to furnish our needs. And that's really usurping the role of God. And so there's a confusion about what is government, human government, and what is God. And you can see that played out. I mean, you in Iowa here can see that played out very firsthand in all the presidential access that you have. But the application of the government as God factor comes into real play as we focus in on the desire of the government to say that the government will tell us how to raise our families. Now, the chief example of the problem, we'll develop this later, is the UN Convention on the Rights of the Child. And as you all know, Hillary Clinton is the chief advocate of the UN Convention on the Rights of the Child. And if she becomes president of the United States, again, I think there's a second argument that we can make that she's already banned by the later amendments to serving because she's already served his 2 terms as president. I don't know, something about the de facto president, the de jure president, anyhow. But if she's president, Kate barred the door. We are in serious trouble on this score. But I'm going to come back to more on the UN Convention on the Rights of the Child in a minute. Parents' rights are protected by the Constitution of the United States, according to the Supreme Court, since the 1920s. In the case, the lead case on this is Pierce versus Society of Sisters, which was a case arising out of Oregon, where the state of Oregon decided they were going to ban all forms of private education and force all people to attend public schools. Now, technically, the private schools could still operate as basically after-school and summer enrichment programs, but all students were required to attend full-time instruction in the public schools, which, as we know them, is a de facto ban on all private schools. And so parents and schools fought suit, and they went to the Supreme Court. The Supreme Court said the parents had the fundamental liberty to direct the upbringing and education of their children, that no state, no government could override that in the fashion that had been done by the state of Oregon. Now, the doctrines of the Supreme Court have evolved, unfortunately, and have taken on some new lingo since that case was decided. And the lingo has divided our rights into 2 groups: fundamental rights and non-fundamental rights. I told a group a little earlier about this, but this kind of reminds me of aspirin and non-aspirin. Some of my friends say that they like to be a little more specific on the non-aspirin before they take it as a painkiller. Fertilizer is non-aspirin, and so but we have fundamental rights and non-fundamental rights. Fundamental rights include freedom of speech, freedom of press, freedom of assembly, abortion rights. Non-fundamental rights include property rights. And the question is, where do parental rights fall in, and what's the difference between the 2 categories? In fundamental rights, the government always has the burden of proof. If they want to override your fundamental rights, they have to prove, A, that there's a justification for this in one of the recognized exceptions, which basically means they have a compelling governmental interest that can't be achieved in any other fashion. Example. someone wants to use freedom of press to publish secret information about our troop movements on the front page of the New York Times. The government would argue it has compelling governmental interest to stop that exercise of freedom of press because it seriously compromises national security. The government would win a case like that because they would make the necessary high-level showing that there is a compelling governmental interest, and which is defined as an interest of the highest order and not otherwise served. Keep in mind, in another important parents' rights religious freedom case, Wisconsin against Yoder, which the Amish won the right to keep their kids out of the public schools and out of any formal schooling after the age of 16. The Supreme Court of the United States held that compulsory attendance, at least for the last 2 years of high school, was not a compelling governmental interest. And if you know how much they worship compulsory government school attendance, you recognize this is a very high standard that the government has to use to overcome, to say that it cannot overcome the rights. And so Yoder is a good example of how strict the compelling interest doctrine and the fundamental rights standard is. Well, non-fundamental rights are completely different. The burden is on the individual at every step. And the government doesn't have to show this interest of the highest order and all that. They simply have to show some rational connection with a legitimate government interest, which is basically anything that's just not blatantly silly, the government's going to win. That's what it amounts to. If it's just absolutely silly law that you can't justify in any way, shape, or form, the government's going to win a non-fundamental rights case. So the question of whether or not parents' rights are a constitutional right is not the issue, because no one contends that they're not a constitutional right. But the question is, are they a fundamental right or a non-fundamental right? And that distinction is a world of difference. Now, if we were to take the current Supreme Court and line them up and see where they stand, there are three camps. There are those that think it's a non-fundamental right. They're basically the leftists on the court. There are those who think it's a fundamental right. And then there's an additional third group, led by Justice Scalia, conservatives, who take the position, though, even though it's an inalienable right under the Declaration of Independence, since it's not in the text of the Constitution itself, judges shouldn't enforce it. And so if Oregon passes a law to ban all private schools, and Pierce versus Society of Sisters goes back to the court, Justice Scalia votes in favor of Oregon. Now, he would write a stinging rebuke to the state of Oregon and say, well, it's a political matter, Oregon's doing the wrong thing here, I think this is short-sighted policy, but Oregon has the ability to do that because parents have no written right to protect their interests. It's in the text of the Constitution. That's Justice Scalia's position. Now, there has not been a constitutional decision on parents' rights since the new two members of the court have been on. Alito and Roberts, we don't know. Now, about a month ago, there was a parents' rights decision relative to a statutory matter in the special education context. And it's too complicated to go in here in much detail. But there were some encouraging signs from Alito and Roberts in that, but we still can't tell because it was a statutory case, not a constitutional case. And so if Alito and Roberts, who generally would agree with Justice Scalia, agree with him on the issue of parents' rights, we have a 5-4 majority against parents' rights being the fundamental right of the Supreme Court. Now, there's two different reasons, but still, you add 5, and you find out that parents' rights as a fundamental right loses if those two justices agree with Scalia. Now, if one of them agrees with Justice Thomas instead of Justice Scalia, then we 5-4 all right. And there are other permutations that are possible. But I'm not willing to put parents' rights onto the kind of track where we have to depend on shifting 5-4 Supreme Court decisions. And we're not talking about whether parents should have the right to win a particular case. We're talking about whether they exist as a constitutionally protected fundamental right. That's the issue. And unless we put parents' rights into the actual text of the Constitution, we're not going to satisfy people like Scalia. I think if it's in the text of the Constitution, Scalia will do a good job because he's generally on our side. He argues as a political matter, it should be protected. But until it's in the text, he's not going to be there for us. That's problem one. Problem two, we're back to the UN Convention on the Rights of the Child. Now, I've been enough about the UN Convention on the Rights of the Child for some time. The Purdue University had me come out last spring and engage in a forum where I was at a de facto debate between a lady who is a lawyer from Canada, who's one of the leading spokesmen, advocates, enforcers of the UN Convention on the Rights of the Child in that country. And so I wrote a scholarly paper. Purdue University is in the process of publishing it, a book, along with the pro-UN stuff. That's the other chapters in the book. My chapter is called Danny's and Blue Berets, and talking about how the UN wants to run the lives of the children. But I felt I needed to know more. And so I'm in the process of getting an advanced law degree from the University of London, Public International Law. A little less than a month ago, I took 4 written exams, one each day, 4 final exams, on various aspects of the international rights of the child. And that was fun. I'm student RE 4693 or something like that. I don't remember my exact number, but they don't know my name, and they don't know exactly what I believe because they never asked me. And it was just read the books, take a test, no live interaction in this course. And so I learned a lot about the treaty context. I learned a lot about other treaties that have children's rights aspects. And the thing that scares me to death is I've got better arguments about children's rights are judicially enforceable in every nation in the world, in courts outside of that nation, national courts, international courts, than the international lawyers and advocates of child rights can think of. Well, the reason I think I've got a different and even more egregious kind of view that I see as possible is that Americans really are more trained and experienced in constitutional law than other countries. Britain, for example, doesn't really have constitutional law, as we know, because they don't have a written constitution. They have legislative supremacy in Britain. They don't have a system. If the Oregon bill passes in Britain, rather, that'd be the end of it. The legislature passes it, it's done. You can't challenge it. And so, because we have this deep history of constitutional thinking and the higher law mentality, then we know how to do constitutional law in, I think, a superior fashion than most of the people in the rest of the world. And if you bring that kind of constitutional thinking into this international law, international human rights law is essentially constitutional law without a constitution, substituting these treaties and these inferences and these customary practices and all this nonsense that's been added up into the body of international law for the express purpose of coercing the world into international socialism. That's what it's really about, and they're very explicit. It's not an inference on my part. They say it quite openly, that there are 5 segments of human rights: economic, social, civil, political, and cultural rights. Your child has if the UN Convention on the Rights of the Child were to pass, your child would have an internationally enforceable human right to play in an equipment. If it's a pressing need, international right to clothing, medical care, all from the government, of course. All from the government. And the government that can force you to have all these things, of course, can force you to pay for all these things. And it's international coercive socialism is what the international human rights movement is about. That, you want to know what it is? When they say human rights, think civil, political, economic, social, and cultural. All 5. They're indivisible, and it's coercive socialism. And so if American-style law merges with the substance of international human rights law, we've got a recipe for disaster coming. Because America was founded on one basic principle. And I hate to bust the bubble of, I wrote this huge book on religious liberty that I'm very thrilled about. I hope you come over and get one after we're done here. I spent 3 years doing it. I have been litigating for 30 years on religious liberty. I believe deeply in religious liberty. I think the battle for religious liberty is what made America, and what made self-government possible. But the real catalyst of what founded America was not religious liberty, because that was not the fight between Britain and the United States in the 1770s. The fight between Britain and the United States in the 1770s is who makes rules for America. That was the issue. And because of charter and practice and tradition, keep in mind, in Britain, they don't have a written constitution, so their constitution is unwritten. So 150 years of unbroken practice is the Constitution of England. And so it was the Constitution of England that the colonies had passed their laws for all domestic purposes. And when the Parliament decided to try to legislate for the United States, they were violating the Constitution, meaning the unbroken traditions of England for over 150 years, as well as the written charters of the colonies. And the American people said, no, you can't break the law that way. And they stood up against the parliaments of Europe and said, you will not legislate for us. We will legislate for ourselves. And they fought a war. And yet here we are in 2007 trying to decide who are going to make the rules for the United States. Are we Americans going to make the rules for the United States? Or is the UN going to make the rules for the United States? I, for one, believe there should be no doubt about it. America should make the rules for the United States, not the UN in any way, shape, or form. One federal judge in New York has already ruled in 2 separate cases that the UN Convention on the Rights of the Child is already binding on the United States because of the doctrine of customary international law, which I don't have to get into. I don't have time to get into the details of why he would say that. But I would say he's not crazy. He's just leftist. There is a legitimate legal argument for his position. And if we do not do something to stop what I call I'm a little tongue-in-cheek when I say it, but not totally. What I call the village idiot movement. It takes a village to raise a child, village idiots. Or you could call them the village people, one or the other. It's okay. The people who think they know how to raise their children better than you do, which is back to that judge in Island County, Washington. How often do you get to kids in church? Well, the village people will make that decision for you. And I believe that parents, not bureaucrats, should decide how children are raised in the United States. And if you believe that, if you believe that like I do, and if you think that I've assessed the problem correctly, then I hope you'll agree with my next thing, and that is, we've got to do something to stop this. We've got to do something to fix the problem. I am not one to sit around and let the problem engulf us. I hope we learned a lesson from homosexual marriage. If it did nothing more than serve as a good object lesson to redeem this area, then, at least some of it will come from some bad. Because anybody that knows Washington, D.C. at all will tell you today that the federal marriage amendment is dead in this political lifetime. Now, if there's a big sea change in Washington where there's a whole cast of new characters, then maybe, it could change. It could change in 3 years, it could change in 5 years. But as of today, it is absolutely dead. In 1997, I made a speech to a group of conservative Christian leaders, national representation here, urging them to adopt a marriage amendment. And the answer was, that's not where we are right now, Mike. Let's wait until there's an acute problem, and then we'll deal with it. Well, guess what? How do you get an acute problem? You get an acute problem because you let things deteriorate to the point that you've got something staring you in the face, and then you're not facing the issue of preserving what you've got. You've got the issue of you're trying to change the status quo. And so when Massachusetts saying we're going to homosexual marriage, we're in a position now of unraveling marriages. We're trying to change the law. We're the ones that are the radicals trying to change the existing order. Well, folks get it. They always are. And if we wait until there's a crisis on parents' rights in this, we will have waited until there's enough of society that shifted their views that we have a crisis. And if you wait that long, there's not enough people in the country who believe in what you believe in to push through the Constitutional Amendment. And the plain fact is that unless 2/3 to 3/4 of the American public actually agrees with you, at least in general principle, you can't pass a Constitutional Amendment. So that's why this speech is called Parental Rights Now or Never. If you simply read the cultural indicators of what's going on in this nation, we will not last more than 10 years before this culture will change so dramatically that the village people will have taken over enough of the minds and the hearts of American people that we can't get it done if we wait any longer than now. And it's a multi-year process to do this. We can't do this week, next week, or 6 months from now, or a year from now. This is going to take 3 years absolute tops, or the quickest you could possibly do it, more like 5 to 7. Now, we've got that much time. But if we're not aggressively on the program today, we can't get there. Because in 5 to 7 years, we've got to be gaining momentum among people who just barely think about this issue. And so the people that care deeply about this issue have got to get on the bandwagon today, not next week, if we're going to make this happen. We've got to be like the Founding Fathers generation of people who have some foresight and some willingness to act in advance of the absolute dire necessity. It's coming. It's not, the UN troops aren't here today. But if you know how to read anything at all about the future, you have to say it's coming and it's real and it's not artificial and we need to act today. How are we going to do that? Well, it's pretty simple. 25% of the Congress and maybe 3 members of the Senate agree with parental rights because they have right principles. And about 25% of each of those chambers will disagree with parental rights because they're village people. And about 50% of each house believes in the highest priority in their political world is, I want to be reelected. And that's what they really believe. And if you want to influence those people, it's not too hard. You just beat them up with more people than the other side has. They remind me of what the Speaker of the House of Iowa said to me when we were battling against the teacher certification law and the whole China bill. How many of you were around when we were doing the China bill? Long ago and far away. After we won a procedural case in the Supreme Court of Iowa, the response was to change the prosecution of truancy from a crime where parents had some procedural rights into a social services case, child in need of assistance in China, named after their favorite country political philosophy. And so I went to the Speaker of the House and talked to him in the hallway. I still see the conversation in my mind's eye. And he said, how many homeschoolers were master? And I told him what I thought. And he said, well, he gave me an exact number. And it was like 100 to 1. He says, I have, I'll say 3,000 public school teachers in my district. That's not the right number. I can't remember. It's so long ago, but it's a big number compared to the homeschoolers. He said, I look at the homeschoolers and I look at public school teachers, and I can count. So I'm not voting with you. No, that's how the vast majority of these politicians think. And we just simply have got to get organized. And I'm convinced that if there's 10,000 people in every congressional district of this country where it's remotely possible to organize such a group, this is about 80% of the districts. I don't think I can organize this kind of force in downtown San Francisco or downtown Boston, or probably not the boroughs of Manhattan unless I can get Spider-Man to help me. And so, 80% of the districts in the country, I think I can get 10,000 people. Well, really, I can't. I might be able to find 10 people who need to find 10 people who need to find 100 each. And so the basic is 10 times 10, that's 100 leaders. And then 100 leaders will get 100 supporters each. There is 10,000 people in the congressional district. Now, how many of you think you know 100 people who believe in parental rights? I bet you every single one of you here know 100 people who believe in parental rights. If you would be willing to tell them, go look at this website and read this stuff and get involved and here, do this, I think we can find 10,000 people in pretty quick order in your sphere of influence by, we've got several hundred, if not 1,000 people here today. And we can rapidly meet the goal for congressional districts in Iowa, and there's some folks from Nebraska here, and some folks from Oklahoma, and so on. And so, you guys can be the leaders that can make this happen. This is not a homeschool only thing. This will help the public school parents every bit as much as homeschool parents. The law today, in several of the federal circuits, is if you drop your kids off at public school, that's that. There was a case recently of a guy named David Parker that I've met and become friends with. He's a Christian guy. Feels like God wants him to stay in front of the public schools as kindergartner. The public school wants to indoctrinate homosexuality. He simply asked to be notified when they were going to do it. That's the only thing he asked. Just tell me when you're going to do this. They refused to do so, arrested him when he insisted on finding out. And they dismissed the criminal charges, as they chickens normally do. But he lost his parental rights claim in the federal district court of Massachusetts. It's going up on appeal, and I'm probably going to help him with a friend of the court brief. But nonetheless, it's cases like that that we're going to help him, because the rules used to be in public schools about 15 years ago, that if a request to opt out of the public schools would only really affect this child, and the parents should have the control to do that. But if there was an opt-out request that was done in a way that would disrupt the education of other kids, then you can't do that. You can't disrupt other kids' education to suit your sensibilities. But there's no way that what he was asking for would disrupt the education of anybody else. And they've not gone to that disruption. They've gone to, if you drop your kids off, you lose them. And we need to stand up for parents' rights in every context. Even if we never choose to be in public schools, we still will stand up for parents' rights in that context. And so we need to organize folks. And I need you to become active supporters of this. Now, I'm going to ask some young men to come forward. Are you here? Yeah, okay. And in your program, you all got, I was told, a copy of a petition about parental rights. If you find that, can you take a look at that and walk you through it? And all these young men and ladies, oh, wonderful. We'll get twice as much success because we have ladies here. It looks like this, and there's a bunch of whereases on the front page, and there's a draft text. So the proposed constitutional amendment is in there. The whereases are a short form of what I just walked you through, okay? And trying to explain why something is needed. And the draft text says that whereas the God-given right of parents to bring an education to children, pause, God-given rights. Don't you think it's about time that we formally recognize in this country that rights come from God? Well, going down to the actual text, it says, what we're doing here in this text, in sections 1 and 2, is restating as accurately as we can, usually with exact words from the Supreme Court. We're just putting in black and white the current standards that the Supreme Court has said are implied rights in the Constitution. So we're changing parental rights from an implied right to an explicit right, and not trying to change the principles at all. Just trying to make them permanent, so that international law and shifting judicial liberalism will change them over the next decade or so. So section 1 says the liberty of parents to directly upbringing and education of their children is a fundamental right. Okay, you guys understand that term now? You see why we say it exactly the way we do? It's a term of art, and it has loaded meaning. And we wouldn't have to say section 2 because we say fundamental right. Whenever you say fundamental right, you get section 2 automatically because you get what's called the compelling interest test. Because the government can override free speech, which is a fundamental right, in the case like I explained to you earlier. But we wanted to say the exclamation clause explicitly for 2 reasons. One is so that we can write the most favorable form of this rule and not let the court make it up and fiddle around with it over the course of time. So we want to say that the most favorable, and this language comes mostly right out of Wisconsin against Yoder. And so the government interest is applied to the persons of the highest order not otherwise certain. Word for word out of Yoder. And so, but the second reason is one of the chief arguments against parental rights in putting in the Constitution is that we're the Constitution to protect child abusers, which is not our intent and will not be the effect of this language. And we can point to this language and say, no. Parents' rights are not absolute rights. They're fundamental rights. They're subject to government override when there's serious issues involved. And child abuse is currently punished, even though the parents' rights are considered a fundamental right, and they will continue to be punished. Child abuse will continue to be punished because it's fundamental rights, not absolute rights. And here's the override clause right here in section 2 that will continue the same policies we have today, that in general principle, if somebody's convicted of child abuse, their parental rights should be overridden. That's the second reason for putting it explicitly in the text. And then the third section is international law must stay out. We're going to override any international law in the text of the Constitution. And the highest level of law in the country that we have, and the most certain that we can do to override international law, is to put it in the text of the Constitution itself. So that's why we're doing that. Now, you've been given envelopes. And I want to tell you something. I spoke to an audience at least this big in Illinois 2 weeks ago. And I think if I take this, let me just take it, I'm going to end this. How many of you think that we should adopt this Parents' Rights Amendment? Okay, that's what I thought. Virtually. If I would have asked that in the Illinois audience 2 weeks ago, I think I would have gotten the same response, right? Okay. I asked them to go to our website and sign up. 27 people did. 27 people, and frankly, there were 2,000 people in the room. And so, I've learned a lesson. We're not signing up on the internet tomorrow. I want you to sign up right now. So, we've got an honor, and I want you to sign up. Now, you can go on the internet and sign up too if you want, or because, I certainly want you to tell your friends to sign up. You go to parentalrights.org and become a citizen co-sponsor. It doesn't cost anything to become a citizen co-sponsor. You can sign this thing today and become a citizen co-sponsor and not let it cost you a thing. And that's okay. But this is a really challenging thing. And we're going to have serious resources behind us. And this is not a 501c3 kind of activity. This is a 501c4 activity. So people can't write big, huge tax deductible gifts to us. It's going to take a bunch of small donations to make this work. And so, and the second thing is that we have to be able to, in order to communicate hardcore political information, what political candidates actually say about this, in order to comply with the FEC, I have to have dues-paying bona fide numbers.
You've been viewing a speech given by Michael Ferris of the Homeschool Legal Defense Association, speaking at a recent conference of the Network of Iowa Christian Home Educators, and on the subject of parental rights. And he is endorsing an amendment to the Constitution which would preserve parental rights. You can get to that by looking at www.parentalrights.org.
Whatever, and we're going to pick these up. I'm going to have the same people. I ask you to pass these envelopes in a minute to the aisle. I want you to start writing your checks and fill this out right now. If you want to be a citizen co-sponsor, write it down right now. Be sure give me your email address if you have one. Because it costs 60 cents minimum to send a letter, and we can't afford it. God communicates to you essentially for free. So give me your email address. So if you can start filling that out and doing all that, well, I'm going to answer questions while you're doing that. Yes, sir.